The Georgetown University Law Center's Hart Auditorium was filled to capacity for the annual Judicial-Legislative Dialogue, a prestigious forum where lawmakers and jurists discussed the intricacies of constitutional interpretation. The distinguished panel included Supreme Court Justice Samuel Alito, known for his textualist approach and incisive legal mind. Representative Jasmine Crockett, a former defense attorney now serving in Congress, had just completed her response to a complex question about statutory interpretation in the digital age. Her answer had woven together historical context, judicial precedent, and practical implications with remarkable clarity. Justice Alito, who had been listening intently, leaned toward his microphone. The audience fell silent in anticipation. Representative Crockett, Justice Alito began, his voice measured and deliberate. I've participated in many of these dialogues over the years, but rarely have I heard such a precise articulation of the competing constitutional principles at stake. Your analysis demonstrates a profound respect for both the letter of the law and the institutional roles our Constitution establishes. He paused briefly, his expression thoughtful. Regardless of where one might land on specific policy questions, your commitment to constitutional fidelity and the rigorous legal reasoning you've displayed today represents the finest tradition of our legal system. It's precisely this kind of thoughtful analysis that advances our constitutional dialogue in meaningful ways. The audience, composed of legal scholars, law students, and public servants from across the ideological spectrum, responded with a unified wave of applause that acknowledged a rare moment of professional respect transcending the usual political divides. What transpired in the following moments wasn't just an unexpected judicial acknowledgement. It was a powerful reminder of how principled legal reasoning could still build bridges in an era of polarization. If you value thoughtful dialogue that elevates our understanding of constitutional principles, please take a moment to like this video and subscribe to our channel for more content that celebrates substantive engagement across our democratic institutions. To appreciate the significance of Justice Alito's recognition of Representative Crockett's legal reasoning, we must understand the backgrounds of these two accomplished legal minds and the complex constitutional question they were addressing. Justice Samuel Alito had built his reputation through decades of rigorous jurisprudence. After graduating from Princeton University and Yale Law School, he served as a U.S. attorney and judge on the Third Circuit Court of Appeals before his appointment to the Supreme Court in 2006. Throughout his career, Alito had consistently advocated for careful textualist readings of the Constitution and statutes, earning respect even from those who disagreed with his conclusions. Justice Alito approaches every legal question with extraordinary precision, noted constitutional scholar Dr. Eleanor Richards. He's known for his close reading of text and historical context, regardless of political implications. On the bench, Alito had established himself as a jurist who demanded rigorous legal reasoning from attorneys appearing before him. His questioning during oral arguments was characteristically penetrating, often focusing on the specific language of statutes and constitutional provisions rather than broader policy considerations. Representative Jasmine Crockett had followed a different path to legal prominence. After graduating with honors from the University of Houston Law Center, she built her reputation as a trial attorney handling complex civil rights cases. Her courtroom experience had honed both her analytical skills and her ability to communicate complicated legal concepts with remarkable clarity. What distinguished Representative Crockett in her legal career, explained former colleague James Washington, was her ability to make sophisticated legal arguments accessible without sacrificing nuance or precision. After entering Congress, Crockett had focused much of her attention on judicial reform and constitutional questions, often surprising colleagues with her emphasis on institutional integrity rather than purely partisan considerations. She had gained notice for her careful study of separation of powers issues and her commitment to constitutional principles, even when they didn't align with immediate political advantages. The question that had prompted their exchange at the Georgetown Forum addressed one of the most challenging constitutional issues facing modern governance: how courts should interpret statutes regulating emerging technologies when the text was written before such technologies existed. This was not merely an academic question. Courts across the country were grappling with how to apply decades-old privacy statutes to artificial intelligence systems, how commerce regulations designed for physical goods should govern digital services, and how First Amendment protections extended to algorithmic speech. The previous speakers had outlined various approaches to these questions, living constitutionalism that emphasized evolving societal values, strict textualism that focused solely on original public meaning, and pragmatic approaches that considered practical consequences alongside text. When the moderator turned to Representative Crockett, many in the audience expected a response that prioritized progressive policy outcomes. What they heard instead was a nuanced analysis that transcended simplistic political categories. The constitutional challenge we face, Crockett had begun, isn't choosing between fidelity to text and recognition of technological change. It's developing an interpretive approach that honors both, that applies enduring constitutional principles to contexts the drafters couldn't have imagined. She had then proceeded to outline an analytical framework that started with textual analysis, but incorporated historical understandings of statutory purpose and constitutional structure. Rather than advocating for courts to update laws unilaterally, she emphasized the distinct roles of the judicial and legislative branches, while acknowledging the challenges created when legislative gridlock prevented statutory updates. It was this balanced, institutionally respectful approach that had prompted Justice Alito's unexpected recognition, a moment that would resonate far beyond the Georgetown auditorium. We're interested in your thoughts on how judges and legislators can work together to address new constitutional challenges. Share your perspectives in the comments on instances where you've seen productive dialogue between our branches of government. The Georgetown University Law Center's annual Judicial-Legislative Dialogue had been designed to foster substantive exchange between branches of government that often viewed each other with institutional wariness. This year's theme, Constitutional Interpretation in the Digital Age, had drawn particular interest given the rapidly evolving technological landscape. The format featured alternating perspectives from judges and legislators, with Justice Alito representing the judicial branch alongside two appellate judges, while Representative Crockett joined senators from both parties in presenting legislative viewpoints. The session had begun with expected positions. Judge William Harrison from the Seventh Circuit had advocated for strict textualism, arguing that courts should apply statutes as written regardless of technological changes, leaving updates entirely to Congress. Senator Michael Roberts had countered that such an approach would create legal vacuums when new technologies emerged, advocating instead for purposive interpretation that looked beyond specific text to broader legislative intent. When Justice Alito was introduced, many attendees anticipated a forceful defense of textualism. Instead, he offered a more nuanced position. The constitutional separation of powers creates distinct responsibilities, he began. Courts must respect legislative text rather than imposing their policy preferences. Yet we cannot ignore that applying clear text to unforeseen contexts sometimes creates genuine interpretive questions that cannot be avoided simply by declaring the language plain. He continued by distinguishing between judicial activism, imposing personal preferences under the guise of interpretation, and the legitimate interpretive work required when applying existing law to novel circumstances. The challenge, Alito explained, is developing consistent, principled approaches that respect legislative supremacy while fulfilling the judicial duty to resolve cases even when technology has outpaced statutory language. Throughout the first hour, the discussion remained substantive but predictable, with speakers largely adhering to familiar theoretical frameworks. The tenor changed when the moderator turned to Representative Crockett for her perspective on a particularly challenging question. Representative Crockett, the moderator began, you've worked extensively on legislation addressing digital privacy. How should courts interpret the Electronic Communications Privacy Act of 1986, written before the commercial Internet existed, when addressing modern surveillance technologies? Crockett approached the podium with the measured confidence of someone who had spent years in courtrooms. Rather than beginning with broad principles, she started with a specific example that immediately captured attention. Last year, the Ninth Circuit had to decide whether law enforcement needed a warrant to access historical location data from a smart thermostat, a device the 1986 Congress couldn't have imagined, she began. The question wasn't whether such surveillance was good policy, but whether the statutory text covered this technology and what constitutional principles should guide interpretation. She displayed the relevant statutory language on the auditorium screens and proceeded to analyze it with remarkable precision, identifying specific terms whose meaning had been transformed by technological change. The statute references electronic communication service and electronic storage, terms that had specific meanings in 1986 but have been fundamentally transformed by cloud computing and the Internet of Things, she explained. When a statute's key terms have undergone technological evolution, courts face a genuine interpretive challenge, not merely a political choice. What distinguished Crockett's analysis was her recognition of legitimate concerns from multiple perspectives. She acknowledged the separation of powers concerns that made courts reluctant to expand statutory coverage beyond explicit text, while also recognizing the privacy implications of creating regulatory gaps for new technologies. The judicious approach, she continued, begins with careful textual analysis but doesn't end there. It examines how the statutory terms were understood when enacted, what underlying privacy interests Congress sought to protect, and how those interests are affected by new technologies. She then turned to constitutional structure, explaining how the Fourth Amendment's principles should inform statutory interpretation when privacy interests are at stake, citing Justice Gorsuch's approach in Carpenter v. United States alongside Justice Sotomayor's concurrence in United States v. Jones. What's striking, Crockett observed, is that justices with very different interpretive philosophies have recognized that applying constitutional principles to new technologies requires more than mechanical application of existing doctrines. Justice Scalia's majority opinion in Kyllo v. United States acknowledged this challenge when addressing thermal imaging technology. Rather than advocating for particular outcomes, Crockett outlined a methodical interpretive process that respected both textual constraints and the need to apply enduring principles to unforeseen technologies. Her approach emphasized judicial restraint without abdicating the responsibility to provide coherent interpretation. When she addressed the role of Congress, Crockett surprised many with her candid assessment of institutional limitations. Congress has a constitutional responsibility to update statutes for technological change, she acknowledged, but we must recognize the practical challenges. The legislative process isn't designed for rapid adaptation, and bipartisan agreement on complex technical issues has become increasingly difficult. She proposed a framework for congressional judicial cooperation, where courts would interpret existing statutes using traditional tools while clearly signaling to Congress where technological change had created genuine gaps requiring legislative attention. This approach, Crockett explained, respects separation of powers while acknowledging institutional realities. Courts shouldn't usurp legislative functions by rewriting statutes, but they also shouldn't pretend textual clarity exists when technological change has genuinely altered statutory terms' practical meaning. Throughout her presentation, Crockett demonstrated remarkable command of both technological details and constitutional principles. Rather than advancing partisan positions, she consistently returned to institutional responsibilities and the need for principled interpretation across changing contexts. When she addressed specific cases, she analyzed majority and dissenting opinions with equal rigor, identifying strengths and limitations in each approach regardless of which justices had authored them. As Crockett concluded her analysis, she directly addressed the judicial panelists. The court's legitimate interpretive role isn't a license to impose policy preferences, she stated firmly, but neither is it a mechanical exercise that can ignore how technological change affects statutory meaning. The challenge for both branches is developing approaches that respect constitutional boundaries while providing citizens clear, consistent rules as technology continues to evolve. Her final point resonated across ideological lines. Whether through textualism, purposivism, or other interpretive approaches, our shared goal should be faithful application of democratically enacted law, with transparent reasoning that citizens can understand and legislators can respond to when updates are needed. That's not judicial activism, it's constitutional fidelity in its truest sense. As Crockett returned to her seat, the auditorium remained unusually quiet. Her analysis had defied easy categorization into the familiar camps of constitutional interpretation, offering instead a nuanced approach that acknowledged legitimate concerns across the spectrum. The moderator turned to Justice Alito for his response, setting the stage for the moment that would soon circulate widely across legal circles and beyond. Justice Alito adjusted his microphone thoughtfully, his expression reflecting the careful consideration that characterized his judicial approach. The audience, comprised largely of legal professionals accustomed to the sometimes heated debates over constitutional interpretation, waited expectantly for his response to Representative Crockett's analysis. "Thank you, Representative Crockett," he began, his tone measured but engaged. I'd like to explore several aspects of your framework for interpreting statutes in technological contexts. What followed wasn't the ideological rebuttal many had anticipated, but rather a substantive dialogue that probed the nuances of Crockett's approach. Alito began by identifying points of agreement, a recognition that technological change created genuine interpretive challenges that couldn't be resolved through simplistic appeals to plain meaning alone. You've correctly identified that when statutory terms like electronic storage evolve through technological innovation, courts face legitimate questions that go beyond political preference, he noted. The challenge is developing consistent interpretive approaches that respect legislative primacy while providing coherent guidance. Alito then posed a series of incisive questions that reflected his textualist philosophy without dismissing Crockett's concerns about technological change. When a statute's key terms have been transformed by technologies its drafters couldn't have anticipated, how do we distinguish between legitimate interpretation and judicial updating of the law? He asked. What limiting principles would guide courts in determining when technological change has sufficiently altered a term's practical meaning to justify departing from its original understanding? Rather than becoming defensive, Crockett engaged directly with these challenging questions. She outlined specific interpretive canons that could guide courts, including the presumption against creating regulatory gaps, the rule that statutes should be interpreted to avoid constitutional questions, and the principle that privacy protections should be construed broadly when technological change has expanded surveillance capabilities. The limiting principle, she explained, is that courts shouldn't create new categories of regulated technology, but may recognize when new technologies functionally replicate those the statute explicitly covers, particularly when the same privacy interests are implicated. She cited specific examples where courts had distinguished between legitimate interpretation and judicial legislation, demonstrating a nuanced understanding of textualist concerns about institutional roles. As their exchange continued, something remarkable became apparent to the audience. Two legal minds approaching constitutional questions from different philosophical perspectives were having a substantive, respectful dialogue that illuminated rather than obscured the complex issues at stake. Alito nodded as Crockett addressed his concern about consistent application. Your point about transparency in reasoning is crucial, he acknowledged. Whatever interpretive approach courts adopt must be consistently applied regardless of the policy outcome in particular cases. When Crockett referenced Justice Scalia's majority opinion in Kylo v. United States as an example of textualist analysis adapting to technological change, Alito smiled slightly. Justice Scalia's approach in Kylo indeed demonstrates that even committed textualists recognize the need for thoughtful application of constitutional principles to new technologies, he agreed. The challenge is doing so with judicial humility rather than policy preference. As their exchange continued, it became clear that while they might ultimately reach different conclusions in specific cases, both shared a commitment to principled legal reasoning and respect for constitutional roles. When the moderator eventually indicated they needed to move on to other panelists, Justice Alito made the statement that would soon be shared widely throughout legal circles. Representative Crockett, Justice Alito began, his voice measured and deliberate. I've participated in many of these dialogues over the years, but rarely have I heard such a precise articulation of the competing constitutional principles at stake. Your analysis demonstrates a profound respect for both the letter of the law and the institutional roles our Constitution establishes. He paused briefly, his expression thoughtful. Regardless of where one might land on specific policy questions, your commitment to constitutional fidelity and the rigorous legal reasoning you've displayed today represents the finest tradition of our legal system. It's precisely this kind of thoughtful analysis that advances our constitutional dialogue in meaningful ways. The audience responded with sustained applause, recognizing not just the significance of Alito's acknowledgement but the substance of the exchange they had witnessed, a model of how constitutional dialogue could transcend political divisions through shared commitment to legal principles. As the applause subsided, several law professors in attendance could be seen making notes, recognizing teaching material that would soon find its way into constitutional law classrooms across the country. For her part, Representative Crockett acknowledged Justice Alito's comments with professional grace. Thank you, Justice Alito. The constitutional questions we face require the best thinking from all interpretive traditions. Our system works best when we engage substantively with competing perspectives rather than dismissing them based on their source. The remainder of the panel continued with a noticeably different tone, more focused on substantive legal analysis and less on ideological positioning. Other panelists referenced points from the Alito-Crockett exchange, building upon the analytical framework they had established rather than retreating to familiar political territory. As the formal session concluded, cameras captured Justice Alito and Representative Crockett continuing their conversation, joined by law students and professors eager to engage with the substantive questions they had raised. "What we just witnessed," remarked Professor James Chan to his constitutional law students who had attended, "was constitutional dialogue at its best, rigorous, principled, and focused on legal reasoning rather than political outcomes. Take note, this is how the system is supposed to work." The exchange, initially notable for the unusual public recognition from a Supreme Court justice, was already becoming something more significant, a model for how legal professionals could engage across philosophical differences through shared commitment to constitutional principles. In the days following the Georgetown Law Forum, videos of the exchange between Justice Alito and Representative Crockett circulated widely through legal circles. What might have remained a noteworthy but limited academic moment soon gained broader attention as law professors, judges, and constitutional scholars highlighted its significance. The Harvard Law Review published an analysis titled Interpretive Common Ground: The Alito-Crockett Dialogue as Constitutional Model, examining how their exchange demonstrated the possibility of substantive engagement across interpretive traditions. "What made this dialogue remarkable," wrote Professor Rebecca Martinez, "wasn't agreement on outcomes, but a shared commitment to rigorous legal reasoning and institutional respect. Both Justice Alito and Representative Crockett demonstrated how constitutional interpretation can transcend political positioning through careful attention to text, structure, and precedent." Law schools across the country incorporated videos of the exchange into constitutional law courses, using it as a case study in productive dialogue between judicial and legislative perspectives. "In 15 years teaching separation of powers, I've rarely found material that so clearly demonstrates how substantive legal analysis can bridge philosophical differences," noted Professor Thomas Richardson of Yale Law School. "My students now analyze the Alito-Crockett framework as a model for approaching novel constitutional questions. The impact extended beyond academic settings. Federal judges began citing the analytical framework Crockett had outlined and Alito had engaged with, in opinions addressing statutory interpretation in technological contexts. In United States v. Martinez, a case involving government access to smart device data, Judge Elena Rodriguez of the Second Circuit wrote, "As Justice Alito and Representative Crockett both recognized in their Georgetown dialogue, applying established statutory terms to transformative technologies requires more than mechanical textualism or free-form purposivism. It demands careful analysis of how technological change affects the practical operation of statutory language while respecting legislative primacy in policy matters." The Chief Justice of the Oregon Supreme Court referenced the exchange in a speech to newly admitted attorneys, emphasizing professional responsibility across branches of government. The dialogue between Justice Alito and Representative Crockett demonstrates that our constitutional system functions best when legal professionals in different roles approach their responsibilities with both principle and humility, she observed. Their exchange reminds us that rigorous legal reasoning transcends political divisions when practiced with institutional respect and fidelity to constitutional principles. Congressional staff reported increased interest in the legislative history materials Crockett had referenced during her analysis. The House Judiciary Committee, recognizing the need for clearer guidance on technological issues, established a bipartisan working group specifically focused on updating statutes whose key terms had been affected by technological change. Senator James Richardson, who co-chaired the working group, explicitly referenced the Georgetown exchange when announcing the initiative. Justice Alito and Representative Crockett identified a crucial gap in our constitutional process: the challenge of applying existing statutory language to unforeseen technologies. This working group aims to provide clearer legislative guidance while respecting the interpretive role of courts. Media coverage, initially limited to legal publications, gradually expanded to include broader discussions about constitutional dialogue. Several major newspapers ran features examining how the Alito-Crockett exchange contrasted with the more common portrayal of government branches in perpetual conflict. At a time when Americans are accustomed to seeing judges and legislators as adversaries in an ideological battle, wrote columnist Michael Stevens, the substantive engagement between Justice Alito and Representative Crockett offers a different model, one where legal reasoning and institutional respect create space for productive dialogue despite philosophical differences. Law professors began documenting the concrete impacts of their exchange. Professor Elena Rodriguez of Columbia tracked judicial opinions that cited their interpretive framework, finding it referenced in decisions from judges appointed by presidents of both parties. What's significant, she noted, is that judges with different jurisprudential approaches are finding analytical value in the framework. It's being used by textualists and purposivists alike, suggesting it offers a methodology that respects multiple interpretive traditions. 6 months after the Georgetown Forum, Justice Alito referenced the exchange during an address at the American Law Institute's annual meeting. My dialogue with Representative Crockett demonstrated something important about our constitutional system, he observed. While we may approach interpretation from different philosophical traditions, substantive legal reasoning creates common ground that transcends political positioning. He continued with a point that surprised some attendees. Her analysis reminded me that textualism at its best has never been about mechanical application of words frozen in time, but rather about faithful interpretation that respects both textual constraints and the need to apply enduring principles to evolving contexts. Representative Crockett similarly acknowledged the impact of their exchange during a congressional oversight hearing on judicial administration. My dialogue with Justice Alito reinforced that our constitutional system depends on each branch respecting the other's legitimate roles while engaging substantively with different perspectives, she noted. When we focus on legal reasoning rather than political advantage, we serve both our institutions and the citizens who depend on them. The long-term significance of their exchange became evident as it influenced both legal education and professional practice. Law schools increasingly emphasized training students to engage substantively across interpretive traditions rather than simply advocating for preferred outcomes. The Alito-Crockett model has changed how we teach constitutional dialogue, explained Professor James Henderson of Stanford Law School. We now explicitly train students to identify legitimate concerns from multiple interpretive traditions and engage with them substantively rather than dismissively. Federal judges reported a subtle but important shift in how attorneys approached oral arguments in cases involving technological interpretation. Rather than framing questions as battles between competing philosophies, more attorneys adopted the integrated analytical approach demonstrated in the Georgetown exchange. We're seeing briefs and arguments that engage more seriously with competing interpretive approaches, noted Judge Maria Vasquez of the Ninth Circuit. Advocates seem more willing to acknowledge legitimate concerns from multiple traditions rather than simply advancing their preferred methodology as the only valid approach. 1 year after their exchange, Justice Alito and Representative Crockett were invited to co-teach a special seminar on statutory interpretation at Georgetown Law. Their course, which included students from diverse ideological backgrounds, modeled the substantive engagement they had demonstrated at the forum. What made this course extraordinary, reported law student Michael Chen, wasn't that Justice Alito and Representative Crockett agreed on outcomes. They often didn't. It was their shared commitment to rigorous legal analysis and their willingness to engage respectfully with competing perspectives. They demonstrated that constitutional dialogue works best when it focuses on substance rather than caricaturing opposing views. As constitutional challenges continue to evolve with changing technology and social conditions, the Alito-Crockett exchange stands as a model of how legal professionals can engage across philosophical differences through shared commitment to rigorous reasoning and institutional respect. The lesson here, noted constitutional scholar Dr. Rebecca Williams, isn't that interpretive differences disappear through dialogue. Rather, it's that substantive engagement with competing perspectives improves legal reasoning regardless of which approach one ultimately adopts. For citizens concerned about constitutional governance in polarized times, their exchange offers hope that our legal system can still function through reasoned dialogue rather than mere power politics. When legal professionals of Justice Alito and Representative Crockett's caliber engage substantively across philosophical differences, observed retired Judge William Harrison, they remind us that our constitutional system was designed not for perfect agreement, but for principled governance despite persistent disagreement. If you found value in this exploration of constructive constitutional dialogue, Please take a moment to like this video and subscribe to our channel. In a media environment often dominated by conflict, we remain committed to highlighting examples of how substantive engagement with legal principles can bridge divisions and strengthen our democratic institutions. America's constitutional challenges will continue to evolve with changing technologies and social conditions. The Alito-Crockett exchange reminds us that addressing these challenges effectively requires not just advocacy for particular positions, but the kind of rigorous analysis and good faith engagement that can build bridges across philosophical differences. In your own discussions of complex constitutional questions, consider how you might apply the lessons from their remarkable dialogue, focusing on principles rather than personalities, seeking to understand competing perspectives rather than dismissing them, and recognizing that legal reasoning at its best transcends political positioning to serve our shared constitutional values.